It's now my pleasure to turn the program over to Mark Updegrove, President and CEO of the LBJ Foundation. Thank you.
Well, welcome, Justice.
Thank you for having me.
And congratulations on listening to the law.
I'm very happy to have it done.
I'll bet. So I want to start with where you start in the book and where you end in the book. And that's with a photograph that is framed on your desk of your great-grandmother's house, in which you have stood only one time when she no longer owned it. What is the significance of that photograph, and why did that house make such a deep impression on you?
So I grew up in New Orleans, and about 10 years ago, my siblings and I rented a party bus to celebrate my dad's 70th birthday. He just turned 80. And my parents both grew up in New Orleans, and they have lots of sites that are very meaningful to them, including my great-grandmother's house on Green Street in New Orleans. And so that was on our tour. I had never seen it before, but my great-grandmother was a widow. She had 13 children. She found out she was pregnant with the 13th after her husband's funeral. So she had a difficult life. This was during the Depression. And I walked into the new owners of the house let us go in to see it, and it was so small. And I was so struck. At the time, Jesse and I have 7 children. Our youngest has Down syndrome, so his special needs require extra care. And I was feeling like my life was at a full expanse. Like, how could I possibly do everything that we had to do? And I saw her house, and I just felt, it was very significant to me because it felt like she was able to stretch herself beyond all reasonable capacity. She took in relatives that needed a place to stay. She fed homeless men who during the Great Depression were the hobos coming through the neighborhood off of her back porch. So she just seemed to multiply very little into much. And so I keep a picture, and since then I always have on my home office desk, just to inspire me to try to keep making use of everything that I have.
So you entered the court in 2020 as an appointee of President Trump in his first term in office, but you had been in the court before. You had clerked for Antonin Scalia in the 1998-1999 term, the legendary conservative justice appointed by Ronald Reagan. So what did you learn from Antonin Scalia that prepared you for being a justice yourself?
So Justice Scalia was entirely devoted to getting it right. He was extremely smart. He's well known for being an excellent writer. And so those legal skills, just the sharpness of his intellect and his analysis, you always had to be on your toes, ready to be articulate and talk about the case, just like the best oral advocates. I learned those things, but he was also incredibly dedicated to making sure that he got the right answer and following the law where it led. And I greatly, greatly respected that, and that is something that I've emulated, and made a theme of the book.
But when you went into the court yourself, what was the greatest adjustment? You had been there, you had seen it. What was the greatest adjustment when you returned as a justice?
So when I returned as a justice, it just is a different time from the time when Justice Scalia was on the court. And the world has just changed. That was 1998, 1999. Everybody was still getting their news in paper newspapers, the Washington Post spread out across the morning breakfast table. And now social media and everybody consumes their news on phones and the internet. The court, everyone's just more recognizable. I often tell the story of when I was clerking. I was with one of Justice O'Connor's clerks in the Great Hall of the court, and there was an exhibit about Justice O'Connor. And a tourist came up to Justice O'Connor in the middle of the exhibit about Justice O'Connor and asked for directions. That just wouldn't happen now in the court. Just, Justice Scalia didn't need security, and he drove himself to work. And, he was able to have, I think, more of a regular life than justices today are.
So we heard this question in Dean DeShazo's classroom from one of the students, but how do you do it with your family? You have a very demanding family life. You and your husband, Jesse, you both have demanding careers. How do you balance all the things that are on your plate at any given time?
That's why I have that picture of my great-grandmother's house on the desk. We try to make use, Jesse and I both do, of every minute. We get up early. I'd like to say that we go to bed really late, but we've increasingly become, 9:30, 10 o'clockers. We can't last. But get up early, and we just try to make use of all of our time. I told the students earlier, and I think it's true, that tasks expand to the amount of time you have to complete them. So we are very efficient. I know that I've got to get my work done during the work day and be home for family dinner, and I can return to it after the kids go to bed. But, Jesse contributes a lot. He does more than his fair share, and for that I'm very grateful.
What was the greatest surprise to you in taking on the role?
When I started at the court, I think the biggest adjustment was definitely becoming a public figure and being recognized, in the grocery store. Just the loss of anonymity and the loss of privacy wasn't something that I had fully internalized when I said yes. And, you had to get used to it real quick. Yeah.
I alluded, Justice, to the upheaval and division that we're seeing in America today. I wonder what your thoughts are in the wake of the political violence and general discord that we've seen over the past months.
I was reflecting on that, especially in this place, and I was thinking of the number of assassinations during President Johnson's presidency. Of course, he came into office when JFK was assassinated, and then there was RFK and Martin Luther King Jr. and Malcolm X. And just during his presidency, that was such a time of political violence and upheaval. And I hope that's not the kind of period that we're moving into now. I think that, I was telling the students this, I think that it's a time of such bitter partisanship that I think one step we can all take is in our own circles and in our own space, working to speak to one another across partisan divides, working on respect and collegiality and civility. I think that's something we actually do pretty well at the court. I describe in the book, I've never heard voices raised in the conference room. It's only the 9 justices in the conference room when we make decisions. Voices are not raised. We go to lunch together. We shake hands before we go on the bench. And I think instantiating some of those practices in our own life is one step forward. But I think, not having no tolerance for violence, I think, is important.
And we can, as you suggest, we can learn from the court. I wonder if the booth can show a photograph that appears in the Justice's book. And this is of your your former boss, Antonin Scalia, and the woman you replaced on the court, the notorious RBG, Justice Ginsburg, on an elephant in India. And you write, live life like Justices Scalia and Ginsburg, who accompanied serious and vigorous public debate with warm personal friendship and mutual respect. Easier said than done, I would imagine, when you have bitter disagreements. How did they do it?
They spent time together. And I think that's one of the secrets of how the court does this. I'm leaning forward. It's something I feel passionately about. We have lunch together every day after oral argument. And after conference. And so we sit roughly 2 weeks of the month, and then we're writing opinions, reading briefs the other 2 weeks. So those weeks that we're sitting, that's 4 days a week that we're having lunch together. Justice Scalia and Justice Ginsburg went to the opera together. They had dinner together. Their families spent New Year's Eve together. They didn't let the fact that they sharply disagreed about matters of constitutional interpretation or politics or anything else stand in the way of being on an elephant together in India. They traveled together. So I think that nowadays, and I see this particularly in young people, it seems like there's this idea that you can't be close friends with people that you disagree with, especially if it's about certain issues. And that's just not true. And that's not how Justices Scalia and Ginsburg lived.
The one, you write in the book about how life works at the court, what your day looks like, and how you render decisions. I think one of the most interesting things about the court, and one of the most secretive things, is the meetings you have with your fellow justices in a conference room. Take us into that conference room and what the decision process looks like as you all speak when you get your turn.
Sure. So the conference room is where the justices meet, always on Friday afternoons. Sometimes we'll have an additional conference earlier in the week, depending on the number of cases. And there's a large table, and only the 9 justices are present. So the court is a branch that does all of its work itself. We have help from law clerks, but there are not staff. There's no law clerks, there's no other staff in the room with the justices when decisions are made. So in fact, there's no job training because no one sees it. It's not like I got to go in there with Justice Scalia, so I knew what happened. I mean, the first time that I went in, I wasn't exactly sure how long I was supposed to speak. I didn't exactly know how it would all unfold. We sit in order of seniority, and we speak in order of seniority. So the chief will kick it off, and then it goes to Justice Thomas, who's the most senior associate justice, and then around the table from there. And each justice lays out his or her view of the case and tentative vote. So I go second to last. The other piece of tradition about our time in conference is that if anyone knocks at the door, the most junior justice answers it. So that was my job for a while, and I've been able to pass the baton to Justice Jackson because no one else can come in the room. So if someone has a delivery, a message, a sweater, if someone's cold to deliver, the most junior justice has to go to the door and get it and bring it in rather than having anyone else enter into the conference room while we're deciding the case.
So you and I were talking in the green room. You are one of 6 justices currently on the court who served as clerks. And you returned to the court to become a peer with those who were on the court when you were a clerk, which has got to be a strange feeling, right?
Yes, I was telling Mark that Justice Thomas and Justice Breyer were both on the court when I was a law clerk. So when I became their colleague, it was very much that feeling of having to start call your parents' friends by their first name. I was like, I'm supposed to call you Clarence now? What? So that was a difficult adjustment. It was a kind of an odd feeling.
There have been a number of controversial decisions that have been rendered since you have gone on the court, one of which is Dobbs versus Jackson Women's Health Organization. That overturned Roe versus Wade, which was rendered in 1973, so it was a precedent that stood for almost half a century. Why was that right to an abortion, which Roe versus Wade gave Americans? Why was that not considered a fundamental right under the due process clause that you write about in the book?
So there are 2 aspects to the Dobbs decision. One is, and this happens anytime the court decides whether to overrule precedent, the threshold question is was the precedent right or wrong? But not every wrong precedent gets overturned. So then the secondary question is, if it's wrong, should it be overturned or should it stay? So with respect to Roe, there had been an interim case, Casey versus Pennsylvania, which had decided solely on stare decisis grounds. It didn't defend Roe's decision on the merits about whether the due process clause protected a right to an abortion or not, but it let it lie on stare decisis grounds, saying that letting the decision stay rather than overturning it would be a way to settle the national controversy surrounding abortion, which it didn't settle in those ensuing years, the court's opinion in Dobbs pointed out. So what I talk about in the book is really a focus primarily on the antecedent question of whether the 14th Amendment's due process clause encompasses the right to an abortion. So I'll try to succinctly describe what I say in the book. The Bill of Rights, the amendments, and the Bill of Rights lays out enumerated rights, so they're expressed. So you can look at the Constitution and say, I have a freedom of speech, freedom of religion, for example, the right to bear arms, to be free from unreasonable searches and seizures, etc. The Constitution also protects unenumerated rights under the court's precedent, and those are housed in the 14th Amendment's Due Process Clause, which says that no person shall be deprived of life, liberty, or property without due process of law. Those rights are not spelled out, and Roe versus Wade had held that a right to terminate a pregnancy was one of the unenumerated rights that was implicit in the word liberty. If liberty means a lot of things, obviously, to a lot of people, and we were just talking about disagreement and polarization. I'll bet if we opened the floor and had discussions about what liberty encompassed and what should have constitutional protection, there would probably be a lot of competing opinions about various rights. So to prevent the court from being 9 people that simply pronounce the rights that we think would be important to the American people, because remember, if a right is protected by the Constitution, it removes it from the democratic process. And it makes it very difficult for the democratic process to regulate it in any way. So to determine whether such a right is protected by the Due Process Clause in that open-ended word liberty, the court asks under its precedent, a case called Washington versus Glucksberg, specifically defined, so you're asking the right to terminate a pregnancy, you're not talking about just liberty or control over one's body more generally. Glucksberg says you must identify the right with specificity and then ask whether that right is firmly rooted in the history and traditions of the American people. And the reason to ask that question is the court should not be telling the American people what rights they should agree to protect, but what rights they have agreed to protect. What rights they do agree are so important that the democratic process can't reach them. Because the court is interpreting the Constitution when it exercises judicial review to decide whether a law is unconstitutional or constitutional, based on what the people have decided. And so that is the metric that the court uses to determine what the people have decided. And Dobbs laid out the evidence to demonstrate that Roe was incorrect to say that a right to terminate a pregnancy had been deeply rooted in the history and tradition of the American people. And its historic roots, its traditional roots were not really in dispute. I think really the dispute between the dissent and the majority and Dobbs was more about the role of the court in making that determination. Whether the court should be forward-looking and identifying rights that should be protected, or whether this history and tradition test should control.
So about 2/3 of Americans believed in the right to an abortion. And as I mentioned, the precedent has stood for 49 years. Should that be considered as you are considering among the court whether this is a fundamental right?
Well, let's see. We didn't check opinion polls, so I'm not sure. I mean, I think there are a lot of polls about abortion. You know, the court doesn't look at opinion polls. I think when you're saying, when you're pointing out that there's support for an abortion, I think that means a lot of things to a lot of different people, even among those who say, because the right to an abortion, you know, let's assume that the Constitution protects such a right. There would be a lot of questions, and the court was involved in drawing a lot of fine lines. Dobbs itself involved the question of where do you draw the line? Is it at the first trimester? Is it at 20 weeks, 21 weeks? It's not a simple on-off switch, a yes or no. It's a pretty complex question. And it was also pretty clear that in the years following Roe, the debate had not died down. It wasn't an issue that there was such, remember, the Constitution has supermajority buy-in. It's a document that trumps all laws that are adopted through the ordinary legislative processes. So you would have to be able to conclude to say that it had the same supermajority buy-in as, say, the right to free speech, that it was supported by a supermajority. And I think when you look at the history and traditions of the people, the way the law had developed in various states over time, it had not become that kind of a settled issue.
So can we expect that other things that they're based on precedent that we might consider fundamental rights, the right to bear arms or the right to use contraception could be overturned by the court?
Well, the right to bear arms is explicit in the Second Amendment. So are you asking more specifically about the unenumerated rights? I mean,
well, I'll take that, to take gun laws off. Any right that we might consider a fundamental right, it has a precedent. And I understand what you're saying about enumerated and unenumerated. But I think there was an expectation that that would be upheld because it was considered a fundamental right. I'm just wondering, can we anticipate that there might be other decisions rendered by the court that take away what we might consider fundamental rights based on the precedents that have been ruled?
Right. So, I mean, Dobbs was about one issue, and Dobbs was very clear that it was about only one issue. So, you know, no, the court, you know, the court of which I'm part is typically called the Roberts Court because courts are named after the justice who's chief at any one time. The Roberts Court actually overturns precedent at a lower rate than its predecessor courts. You know, the statistics, when you look at the rate of overruling, the Roberts Court has overruled precedents roughly once a year. It was about twice per year, roughly, during the Rehnquist years. It was at about 3 a year during the Warren and Berger years. So precedent, you know, this principle that generally speaking, the court stays the course and doesn't overturn its decisions, you know, that is the far and away the general rule. That's how the doctrine works. But no justice has ever said that all precedents are, let's see, the doctrine of stare decisis itself recognizes that the court sometimes makes mistakes and that it corrects mistakes. But that is very much the exception rather than the rule by the terms of the doctrine. And if you look at the numbers on the docket, that bears it out.
I wonder, when you're making these tough decisions, just really difficult decisions, how do you rely on the other justices? Do you talk to them? Do you commiserate with them? How does that work?
So are you talking about when we go through the decision-making process, or?
I guess the decision-making process, but also a monumental decision like that, that's got to weigh on you. Do you look to the other justices to help to guide you, or to commiserate with, or to just talk about the weight that you bear?
So the way the court works, it's almost like 9 independent law firms within the court. Each justice has his or her own chambers. So I've got 4 law clerks and 3 staff members. So when I'm deciding a case, and this is the same for my colleagues, when we're working through it, before argument, after argument, before conference, and during the opinion writing process, I'm really talking about the case primarily with my own staff, with my own law clerks. And then the justices talk in the conference room. So that is the primary place where the justices hash out the case with one another. That's not to say people don't have other informal conversations, but really it is focused with all of us as a group together around that table in the conference room.
Let me talk about another controversial decision, which is Vasquez versus Noem, that allows federal agents to target people for deportation based on, among other things, race and language. Do you worry about the precedent that sets, and that we might disproportionately target those who are of color or of different ethnic backgrounds?
Well, that is a pending case. So one of the rules of the court, and one of the ethical rules that justices have to follow, is that I can't talk about cases that are pending, only cases that have already been decided. And Vasquez is a case that came up, or the Noem case that you're referring to is a case that came up on the court's emergency or interim docket. And so the court has not rendered a decision on the merits of that case. It is continuing to be litigated in the cases in the courts below, and probably will come back up on the merits at some point in the future.
So this was mentioned in the session with JR too. Emergency dockets, also called shadow dockets, are on the rise. You devote a part of a chapter in the book to emergency dockets. Talk about what an emergency docket is.
Yes. So the thing I spend the most time on the book is the thing that's probably the most familiar to you all, and that is our regular merits docket. And that's the cases that proceed at the normal pace. They come to us after they've been fully litigated below, and then we have a decision from the courts below. We hear oral argument, we get briefs, and we go through that process that I described of sitting around the table in the conference room. The cases that come up in an interim posture on the court's emergency docket are on a different track. So these are cases that have not yet been fully resolved by the courts below, and we are asked to intervene by one of the parties below to kind of set a default rule that will be in place as the case is litigated and as the court decides it. So for example, if a district court enjoins a policy that's been adopted by an administration, a presidential administration, sometimes that administration will come to us and ask for the injunction to be lifted so that it can continue enforcing its policy while the legality of that policy is fully litigated. Or if a district court, lower court, refuses to enjoin the policy, then the people who have sued, say the administration in my hypothetical, these cases don't come up only in the context of the administration, but since that was your hypothetical, I'll put it in those terms, might ask us to enjoin the policy so that the policy can't be enforced while it's being challenged in the lower courts. These are not cases We very rarely have oral argument on these cases. These are not cases where we go and sit around the table in the conference room. These are not cases where we circulate the opinions normally, as we do in the merits cases. And as I describe in the book, when we have a merits opinion, we spend a lot of time going back and forth. These interim cases, we don't have any of that, and we don't have time because the entire premise of it is, please act quickly because we need you to set one default rule or the other. Either this policy can stay in place or it can't while the litigation plays out. So those are the interim cases. I think it's very important to understand that when we render decisions, which is why I can't talk about that other case, these are not final adjudications. They are just interim decisions, and they turn on more than just, the standard is, does the applicant who comes to seek the court's intervention have a fair prospect of success? And then there are other factors that we take into account, like what irreparable harm might there be if we don't give this person relief, whatever kind of relief they seek? And what is the balance of the equities that's at stake? So all to say, this is a different animal. It happens in a different time frame with different decision-making inputs, with a different standard, and it's not a final resolution of the case. And I think the way that the cases get reported, and because it's an unusual beast, it's not what people are usually used to seeing from the court, I think they get blurred, but it is a very different track.
Do you think emergency dockets have a place in the court? Do you think that there's too much reliance on the emergency docket?
Well, Justice Kavanaugh observed in one opinion, and he's entirely right, we have to rule on them when they come, so we don't have much choice. When somebody files a motion before the court, you either have to grant it or deny it. So it's certainly a new phenomenon, and there are a lot of theories about why it might be on the rise, but the court has to rule on the applications that it receives, so we can't close our doors to business and say we're no longer taking the applications. So when the applications come, and we're not the only ones having to make this adjustment, because the district courts and the courts of appeals are having to move at the same pace and deal with the same kind of litigation as well. Now, when I started on the Seventh Circuit, one of my colleagues who had been a district judge was explaining to me, and she was doing it in the context of saying, like, let's not be, understand where the district court is coming from. She said, I spent many years on the district court, and the district court is like the ER. You just have, her husband was a doctor, so she was like, you have patients coming in, and you're just trying to do what you can. You're stemming the bleeding, and you're not spending a lot of time with each patient to make the diagnosis, or as much time as you do have up here at the Court of Appeals. We're the specialist, she said. You sit down and you have time to reflect. You have more time to think. And that's true at the Supreme Court, too. However, the emergency docket has all of us functioning like an ER. So all of us are taking the cases on a much higher pace with a much less time to spend, to sit and dwell, and to think, and to read briefs, and do all of the things that I describe in the regular merits process.
But let me understand, Justice, you could deny them. You could choose not to take them. Is that right?
No, that's not right.
It's not right.
That's
I
not
apologize.
Right. So we do have to, let's see, we can deny them, but we can only deny them after applying the standards. So every application that gets filed, there's a 4-factor test that we have to apply, and we can only deny it after concluding that the applicant does not have a reasonable or a fair prospect of success on the merits and won't suffer irreparable harm. So in other words, we can't deny it because we're refusing to decide it. So the applicant who comes to us is entitled to have us apply the test, and that test engages us in the factors including the reasonable prospect of success on the merits, fair prospect of success on the merits.
So one of the points you make in the book is that the opinions really matter, and that if you want to know about a case, read the opinions. Makes perfect sense. You cite your brother-in-law who read the Dobbs, all 29 pages of the Dobbs decision.
Oh, it's more than 29 pages.
Oh, I apologize. Okay,
yeah.
Fair enough.
Because he had all the separate opinions too.
And you hugged him because that's what you want people to do. If they think a decision is controversial, read the opinions.
Yes.
But yeah, you write that opinions give every reader an opportunity to critique a decision on its merits, and you write further that opinions are the court's most important work product. But emergency dockets don't typically include a legal opinion, nor do they include signatories. So how are we to know how the verdicts were rendered? And how are judges at lower levels to know how to apply them?
I think that's a great question. I think, I said, and I believe, and I encourage you all to read the court's opinions. When the court renders a final decision and settles, we talked a little while ago about stare decisis, and how once the court decides a case, then it becomes a precedent. And the default rule, all lower courts follow it, and then the default rule is that the Supreme Court will continue to follow it absent some serious reason to overturn it. So the opinion is important, and it's a conclusive settlement. The emergency docket is not a conclusive settlement. It's an interim, temporary rule. It's kind of it's making a decision that will be in place for the duration of the litigation below, but it's not something in contrast to a full decision that's rendered on the merits after reaching judgment below and then judgment in the court that then goes in the U.S. reports and governs going forward. So the interim docket is not that conclusive resolution of the case as you have in the other one. I was telling the students when they asked this question that one thing that we have to be careful of, I think we are also figuring this out and making judgments because the emergency docket or the volume of it is new. My view, which is something that I say in the book and I have said in other settings, is that one downside of writing opinions on the emergency docket in this interim posture is that it can have the effect of locking in, of setting something in stone that really should be an interim posture, because there is a difference between asking whether someone has a fair prospect of success on the merits and asking whether he has the winning argument. And writing it out in a decision makes it more difficult for the court to back away from it later. Not impossible, because as a legal matter, it is just an interim rule. But I think that's a problem. Or one potential problem. And so we have to balance giving guidance to lower courts, the importance of transparency, the importance of creating order in litigation, especially when the same issue is coming up on the interim docket from different courts around the country. Those are factors. But then there's also, is it always a good thing to have an opinion? And then there's also the practical reality that on a multi-member court, it can be difficult and it can take time, as I described with respect to the merits process. If you have to have the agreement, imagine all the cooks in the kitchen. If you're going to have 5, 6, 7, 8, or 9 justices agree on an opinion, on its reasoning, that takes a lot of back and forth and wordsmithing. If I write a concurrence or if I write a dissent that represents just my own views, I can say whatever I want. I don't have to be particularly stressed because it's not going to be precedent, that controls future decisions, because it's just my view. It's not the view of the court. And I don't have to take things out or phrase things differently if somebody asks me to, because it's my opinion. That's not true for majority opinion. So when you have something on the interim docket, which is supposed to be decided quickly, which is supposed to be a quick turnaround, it's difficult, and not everybody might see it the same way. People might have different views, and then it's not helpful if you have a bunch of different opinions rather than one for the court. There's a reason why June is the big month where cases come out, because it usually takes the court months and months and months in big cases to finish writing all the separate opinions, to finish negotiating back and forth about every word and phrase, in a majority opinion.
Another point you make in the book, Justice, is that the overwhelming majority of the decisions that you make as a body are not on party lines. And I say party lines based on the party of the president who appointed the justice. I believe in 2022, there were only 5 cases that were decided on those grounds. In 2023, it was only 11. But if you look at the emergency dockets, since the second Trump administration began, the executive branch has filed 25 emergency dockets. 24 have been acted on by the court. 21 have been decided in part or entirely in the administration's favor, and only 2 against the administration. So do you worry about these decisions being perceived as partisan driven?
Let's see. I guess people will say the court can't worry, and I make a big point of this in the book, the court cannot make decisions based on fear of criticism. The court has to make decisions based on an assessment of what the legal issues require. And another important thing to remember, too, is that the court has to make decisions with respect to each case and the legal issues that are presented by each individual case, and also looking at decisions. And on the emergency docket, as I said, these are four-factor cases. They're not just about the merits, but you're thinking about, and I feel like I've emphasized this with some students before, and some of my students, you're thinking about the presidency, not the president. In other words, you're looking at the office, not the individual occupant of the office, because all decisions you make, whether the emergency docket or on the merits docket, are decisions that are about the structure of power rather than individual people. Because the Constitution, even though when the Constitution was ratified, the framers may have had George Washington in mind, it was not written for one man. It was written for a presidency. And I'm conscious of the fact I'm speaking to a presidential historian here. So one of the things that I try to do in the book is open up the court's decision-making process, because I want people to understand that this is 9 people. These are 9 justices working hard to confront the legal issues they face and trying to get it right. And as you said, about just under 50% of cases per year are unanimous. And then when you're getting into that other number, it's all kinds of configurations, all kinds of spreads. And there's a very small percentage of them that do break down by party of appointing president. And I don't think that that's a statistic or a number that people are really aware of based on kind of how the court gets publicly discussed.
I think another point that you make in the book is that sometimes you have to make a decision constitutionally that you don't believe in personally. And you cite Justice Scalia, who decided a case that allowed Americans to burn the flag, although he found that personally repugnant. How do you deal with that?
Well, that's the oath. I've taken an oath to uphold the laws of the United States, and that doesn't just mean the laws that I like, and it doesn't mean that I get to impose my personal beliefs on the American people. I mean, we live in a pluralistic society, and people have a lot of different views, including views that differ and sometimes very sharply from my own views. I write in the book that before I was on the bench, when I was a law student, I wrote an article expressing opposition to the death penalty. But I sit on death penalty cases, and I have, voted to affirm death sentences, or say that, there's no legal error in those cases. I think that is the backbone that's required in the job, and I think that's one of the, probably the most important character trait for any judge, is to be able to set aside the judge's own personal beliefs and preferences to follow the law and do what the law requires.
A recent NPR PBS poll reflects the fact that over 3/4 of Americans worry about the state of democracy. Do you worry that our democracy is eroding?
I want people to have confidence in our democracy. I think when I was saying before, reflecting on Johnson's presidency and the political turmoil and even violence that occurred during the years of his presidency, I think it helps to step back and look at the sweep of American history. And I do that from the perspective of the court, because that's the perspective that I have. We have been through a lot as a country. We have been through times of war. We've been through times of great upheaval. And we have always come out, thus far, we've always come out stronger. And I have great hope and I have great optimism in America. And so I want us to have confidence in our democracy. I want us to have confidence in our institutions, because it's only if we have confidence that we can move forward and that we can bring to fulfillment the promises of democracy, the promises of the Constitution and of our institutions. You
talked about institutions. The confidence in our institutions is faltering too, and that might be reflective in the statistic I just gave you. Another poll suggests that in the last 5 years, the confidence in the Supreme Court has eroded. It's gone down 22% from 70% back in 2020 to 48% today. Does the court worry about that, Justice?
I want people to have confidence in the court. As I said, I do not, and I don't think justices can or do, take public opinion into account in deciding cases, because that would interfere with the judicial obligation to do what the law requires, even if it's unpopular. But I certainly think that all of us, and I guess I should just speak for myself, want people to have confidence in the court as an institution. And so really that is the main motivation for my writing the book, is because I want people to get to know the court. I want to invite people in, because even if you don't agree with any particular decision, I want you to be able to engage with it on the terms that the court has engaged with it. I want you to see the legal analysis. That's why I hugged my brother-in-law when he walked in, not just with the majority, and I think you don't read just the majority and you don't read just the dissent of any opinion. Read both. I want people to understand, and I think the court really is the most transparent branch of government in this respect. We do, as I said about the conference room, do our own work, and we have to show it. So the opinions that we produce show our work. We have to say why we reach the decisions that we do. So I want people to see what we do, and my hope, my very great hope, is that people will have more confidence in institutions once they're familiar with them.
Do your colleagues worry about that? Is it something you discuss openly, Justice, the notion of the American people losing faith in our institutions generally, but also in the Supreme Court specifically? One
thing I am very careful to do in the book, and I'll be very careful here, is not to reveal internal confidences, so my lips are sealed.
That was a rhetorical question, because I've read the book and I know that the justice categorically states that in the book. So thank you for that. I wonder, of course, we have three branches of government, and they're co-equal, so-called. But the court has no means of enforcement except to find somebody in contempt. Most of the means of enforcement falls under the executive branch. So is the Supreme Court, is the judicial branch really a co-equal branch of government?
Well, Alexander Hamilton called us the least dangerous branch for precisely that reason. We don't have the power of the purse or the power of the sword. We have the power of judgment. So that is what the Constitution designed us to do, is to produce judgments. So we are independent, but we are the weakest of the branches.
Yeah. I'm going to ask a question that I also know the answer to, because I read the book. But you answered so eloquently, and that is, do you like your job?
So what I say in the book is, when people ask me that question, it feels like not quite the right question, because it feels like an odd thing to focus on what I do or don't get out of it, to say, yeah, I like it, or I'm fully satisfied, I'm really satisfied in the work I'm doing right now. I regard the job as public service, and I'm privileged to serve. And I think there are hard things about it, there are some good things about it, and there are some hard things about it. But most of all, I regard it as an honor to serve the country, and I regard it as a privilege to serve the country.
When we were talking to those young students today, both law students and public affairs students, somebody asked you, something along the lines of, why should they continue in jobs like that? Why should they pursue jobs in the public sector? What would your answer be to young people seeking your guidance on whether they should go into public service?
Because we need good young people, good people generally, right? But young people are the future, and we need good people in public service. All public service is a sacrifice. Most jobs in public service, you take a financial hit, because you could make more in the private sector than you can in the public sector. There are things that are difficult about any public job that requires you to be accountable to the public and be in the public eye and be the subject of criticism. But it's worth it, because if we don't have good people taking jobs, then willing to do that kind of service. It's just like if we didn't have people willing to serve in the military. All of these things are necessary to make us a great nation. And so, yes, I encourage young people to pursue jobs in the public sector and to devote their talents to the greater good of the country.
I talked just about the weight that you carry as one of 9 Supreme Court justices. I wonder what you've learned about yourself as you've embarked on this role.
That's an interesting question. I will say I've been doing a number of interviews and no one has asked me that.
Yeah, I'm
So
good.
good job. You're good. Yeah, you're good. Emergency docket, yes, but what have you learned about yourself? No. I think one thing that this job requires is the ability to be very tough and impervious to criticism. And I think 10 years ago, before I was a judge, I didn't know how thick my skin could be. And I really feel like I have had to acquire a very thick skin and learn to not care what people say or think. And I've been able to do that. And I think if I could be my younger self looking up at my older self, I would be surprised by that, because it has been a hard skill to acquire over, my years of adulthood.
But that's got to take a toll on you and your family. How do you deal with that?
It hasn't taken a toll, I would say, on me because, I guess that's not true. I mean, it certainly is difficult, but I'm at peace with it. I really am. So it's not, I don't lie awake at night worrying about it. I have a policy, which you know since you read the book, I don't read news about myself.
Right.
My husband just tells me things on a need-to-know basis. And most things don't pass the need-to-know standard. Every now and then I'll ask him about something and he'll say, I don't think you need to know. and there are techniques like that that help me kind of keep grounded. And there's nothing that will keep you grounded more than coming home. We have 4 children at home who range from high school to middle school. They really don't care about what's going on at work. I mean, they care about some things. They'll ask about, what cases are you hearing this week? But they're mostly occupied with their own concerns and their own soccer games and their own homework. And that really is our focus as a family. And there's nothing that will keep you more grounded and help you take your mind off of that stuff more than dealing with the concerns of your children.
And it has to help if you have a profound sense of purpose, as surely you do when you sit in a position like that.
Yeah.
So I commend the book to all of you, and there are signed copies. The justice was kind enough to sign 400 copies in a feat of endurance earlier today, many of which, or some of which, may be for sale in the lobby as you leave. So I commend it to you. But if there's one lesson from this book that you would want people to derive to get a clearer picture of what you and your colleagues do on the court, what might that be?
I would want you to see, and I feel like I've said this throughout, and so I'll conclude by trying to say it just one more time. I want people to understand what the court does, and I want them to feel part of it. I want you to, because the court belongs to everyone. I mean, the court is a public institution. The Constitution belongs to all of us. I want you who read the book to feel like you come away understanding how the court operates, what the justices do, be equipped to critique its work, because I don't expect you, and I didn't write the book because I want everyone to think that the court is a perfect institution. It's a human institution. But I want you to have confidence in it, and I want you to love the Constitution, and I want you to love the American government. We're coming up on our 250th anniversary of America next year, and so I think it's an apt time to reflect and to be grateful for the institutions that we have, and I'm privileged to play just a small part in one of them.
Well, we are grateful for your time tonight and grateful for what you do for our nation. Ladies and gentlemen, please join me in thanking Justice Amy Coney Barrett.